There was a case yesterday or day before, I think Aichar Chaudhuri, that no witnesses were present.
Yes.
What was the item?
Yesterday.
Yesterday's.
Yes.
Can you just find it
Yes,
out?
yes. May I put-
Yes.
So I beg to mention item number 18, Lordship, bail hearing matter, Lordship. CD not received, Lordship.
Yes, Pritish.
CD not received, Lordship, and there were interim.
Interim.
26, Lordship.
18/6.
May I feel the Lordship?
18/6.
20.
18/1/8. 20. 26.
26.
Okay.
May I feel the Lordship?
In time, ma'am.
Interim to continue. You have to do it from Hanaka. Oh, it will take one more. Okay. Yes,
I beg to mention item number 22.
22. Yes.
Another AB is pending, my lord, arising out of the same, my lord, affair. That is 1311. Can it be taken up with this matter?
Why this office note? What is this office note?
This was issued to the private respondent because it is a POXO case.
Ah,
So that is why, my lord, office.
why
note-
notice is served or what?
In this case, it is sub. In this
Okay.
case, private.
Mm. Any interim?
No, CD is available.
It is submitted by the learned counsel for the petitioner that another bail application arising out of
AB one.
the same police station case numbered as
Bail application number AB 131.
AB 1311 is pending. Full stop. List both the matters together on
Next week, any day.
give a date next week.
CD is available. CD is available.
Monday.
Monday. Obliged.
May I please, Your Lordship?
Yes.
My lord, I beg to mention for listing a IA in criminal appeal, leftover matter, the petitioner behind the bar more than 1 year, 5 years conviction. His co-equest and other two co-equests already released on bail
By
by this honorable court,
this court or
No.
any other court.
any other court, by this honorable high court.
Okay.
May I please, Lordship, I am prayer for listing criminal appeal, Lordship. Supposed to be listed after 10 days, but not listed yet, Lordship.
Criminal appeal admitted, huh?
Punishment permits.
Above 10 years. Then you may make a mention in that bench. Yes.
Please, Lordship. Lordship, item number 43, I recommend item number 43, Lordship.
Yes.
Leading counsel, Mr. A.M. Bora is out of station, Lordship.
Huh?
Leading counsel, Mr. A.M. Bora is out of station, Lordship.
Item 14.
43.
That cannot be a ground to seek adjournment. Seniors will say seniors, you engage some other senior.
Lordship,
That cannot be a ground to make an adjournment. Don't make such kind of mention. Yes.
Lordship. Kindly for 1 week, Lordship. This I am.
This is
Lordship. I beg to mention item number 30, Lordship.
on the prayer of the learned counsel for the petitioner. List this matter after 3 weeks. Huh? Huh? 40? Let us see. I heard it's 14. 43.
43, Lordship.
Any stay?
Order.
No stay order. After 3 weeks.
May I please, Lordship? Lordship, I beg to mention item number 30, Lordship. Here, Lordship, become infraction, Lordship. He has already been arrested, Lordship. 30.
Dismiss. Become influence. Yes.
Obliged.
May I please, your lordship, I beg to mention for listing an AB, it is fixed, the charge sheet has been filed and the matter is fixed this Monday before the lower court, before the court below, and tomorrow is the last chance. If even the last item tomorrow, the anticipated bill
No,
matter.
no, tell us. And no date was fixed.
Tomorrow is the first date for appearance, your lordship. Sorry, Monday, 10th of June is the first date of appearance.
Now,
before the-
AB, there is an interim order.
We have filed the AP, we are praying for listing of the matter tomorrow. Because non-bailable warrant is also issued, your lordship. Monday is the next date before the lower court and tomorrow is the last working day. Much obliged, your lordship.
This is for the first time
Indeed.
to be listed as motion.
Motion indeed.
Oh, motion permitted.
Much obliged.
Lordship, for listing a IA criminal already, in this honorable court,
Next week, give a date next week, next week,
Same prayer.
next week, give a date next week.
Well, there are two items, my lord.
Hmm.
In the Quashman column, my lord.
Yes,
I will do 39, I'll do, my lord. And so far, my lord, 46, my lord.
item number 39,
39, I'll do, my lord.
yes.
And 46, can it be next week, my lord? I've taken the consent of Mr. Das also, D Das,
46.
46.
Okay, this is
That NDPS case.
NDPS, and what was this 39?
That's regarding, my lord, that notification of withdrawal of cases.
Okay.
By the state.
Dear Lordship,
In fact, my lord, Mr. Pukon.
Pukon, we have requested.
He yesterday he called me up, my lord.
Ah.
That he was out of station, he cannot do. But however, I will do my part, my lord. I'll give a written.
No, let us do some other day. Give up a convenient day if Pukon is not there.
Monday,
Tuesday,
And then 46, my lord, on 13, my lord, because another case is also there.
40th on the prayer of Datta, item 46 on
13,
14th,
13, 1, 3.
1-3.
One.
And this criminal petition, let that be also on 13th.
Yeah, but Two cases,
Two
my lord,
cases, okay.
same day, my lord.
Okay, then 39 when?
How do I do it?
11th?
11.
11.
I'm obliged.
39. Oh, no.
Here also, we may seek Makhon Pukon's assistance because 46,
Lordship.
these are
Okay.
important issues. Or Mr. Das, whosoever.
My lord.
This is basically, Mr. Datta has argued a proposition that this
He's not
this,
a narcotic.
this
Under the
medicines
cosmetics and
was in
drugs.
the form of drugs. If it contains that is not a narcotic. And therefore narcotic acts cannot be made applicable. There may be offenses which is under drugs and cosmetics acts. Okay, there are two views by different high courts. There are some Supreme Court judgments. I will not disclose those
I mean,
I know,
examining.
because I did my own own research
I.
and I was ready today. And you also be ready to have
Yes, my lord.
rounds of firing.
But the point is that, my lord, that section 8 is not discussed anywhere. That's the point. That's the point.
No, 8 is also discussed. 8 is also
in
discussed.
Supreme Court-
Therefore, be ready with the firings from this court.
In one Supreme Court judgment, it is discussed.
With regard to-
Section 8. no?
That is with regard to psychotropic, not narcotics.
Let us see.
Well,
Let
anyway,
us see.
well, I'm obliged.
But let me also explain, just tell us that why I'm saying that you will be ready with the firings because till now I am not convinced with the argument. Look, let me be frank.
Fine.
So, but I am open to that. If you can convince, then we will not dare to hesitate to pass orders. That is clear.
My best to convince.
Yes.
Motion B, item number 1.
May it please your lordship. Lordship, this is a 439 application,
What
lordship.
is the FIR?
Lordship, FIR on page number 8,
Page?
page 8 to 14. Lord. Lordship, he was arrested on 23/5/2024.
NDPS.
No, Lordship.
What is the FIR?
FIR starts at
FIR
page
starts at
9,
page-
Lordship, but
Page
effect-
9.
page 9, Lordship, it was filed after pursuant to order dated 14/5/24.
Be it informed that so-and-so honorable court additional so-and-so has directed me to
Yes.
forward a copy of the, where is the order?
Page 10.
Page 10, Lord.
Very serious matter, Lordship. Lordship can straightway come to the forwarding also, Lordship. That is also exhaustive, Lordship.
Okay, case there is.
Lordship.
By lordship.
Date
20.
Huh? Yeah, yes.
Application FI page 7. NSR 1.
How many days?
22 days, my lord. And my humble prayer before Roshi.
What is the statutory period?
60.
60 days. Yes, give a short date.
Simple prayer before Roshi. My 18 or 19. Applicant is not named FIR and Sejal list from Sejal. Applicant accused is not named in the FIR and also in Sejal list. Matters which are mentioned in FIR. Any item not says from the
Okay, we'll see on how, when?
19. Lordship.
19.
Item three,
Section seems to be serious.
So CD.
CD Lordship.
Notice when we issued to the informant, they are postponed.
Notice to the informant. This is POXO. POXO, notice to the informant, full stop. The petitioner to take steps in terms of the notification number 17 dated 30, Muslim, 15/3/2024.
24th Lordship.
24th.
item four,
What is the FIR?
Page number 9.
Space 9. CD.
Little short date, Lordship.
Ask.
24th Lordship. The notice will approve.
Oh, right, right.
Theft of 3 cows, my lord, recovered.
Huh?
Theft of 3 cows, my lord, and recovered, my lord. My lord, that cow thief has come to the court, my lord. Go to show. 16 days, my lord.
To the satisfaction of
CGM Morigaon.
CGM Morgan, period of detention.
I'm obliged.
50 supplementary list.
FI is the page 9, my lord.
Is 9.
9. 3 HP, my lord.
Hmm.
380. My lord, here one of the co-accused was released on bail by your lordship, my lord.
Okay, when Mr. Yes, Lordship, huh?
Otherwise, 31 days, my lord.
Just went on 24th
Lordship.
or
My lord,
20,
can it be before 17, my lord?
Lordship,
Before
same
17.
same as item number 2 Lordship.
before 17, huh? Same which?
Item number
Same, same.
Lordship.
That's when you fix
It was fixed on 19th.
19th.
My lord, other one also same accused, shown as that. 51.
Okay, 19th.
19th.
Apply.
Item number six. AB,
What is the effect?
Page number 8.
They are co-villagers and neighbors, your lordship. Out of a previous grudge, your lordship, this affair has been wrong. An amicable settlement has been done through a Vichar Sabha also, your lordship. That is also evidence.
What is this? How this registry can accept this kind of documents?
Lordship.
No space, nothing of that sort. We will throw anything and everything. I'll dismiss this off for being defective.
I'll find it.
No, that is not the way. When?
Lordship, CD, it's on Dhubri Lordship, 24th Lordship.
24th. CD.
Should also go to the informant.
Huh?
Your lordship. Should also go to the informant. POXO matter, your lordship.
Notice to the informant. In terms of notification number 17 dated so and so. 15 so. It will keep on. Okay. Notification 7, just remember the date.
Oblige, lordship.
On when? Date?
24th.
Yes.
Oblige, lordship.
7,
Please, your lord.
Yes, where is the FIR?
If the FIR is at case 13, my lord.
Yes, 13.
It's a type copy, my lord. Here.
There is some similar method, same person or what?
No, my lord, it's a very complicated case, my lord. What happened, my lord? This lordship will turn to page 17, my lord, for a once, my lord. 17A B, my lord, 17B, my lord. But this deed of agreement, my lord.
Hmm.
There is a deed. Neither I have signed this deed of agreement, neither I am there, my lord. Neither I have received the amount also, my lord.
So this is your,
I am Gilwan Hussain, my lord.
so according to you, this deed of agreement is not yours.
Yes,
Have
my
you
lord.
lost any FIR?
Yes,
Where is that?
that is the last page, my lord. My lord, and when I received the 41 in notice, my lord,
Hmm.
I applied for the certified copy. And while receiving the certified copy, my lord, my I card was also there, my Aadhaar card, and this agreement, my lord.
Hard. Mr. NJ Datta, this is an application under suspensions. Full stop. The petitioner has taken a specific stance that the petitioner has no business transaction with the informant in as much as the business transaction on the basis of which the affair was lost is in fact a forged document. Accordingly, the petitioner has also filed an FIR
Page 26.
before the officer in charge, Khatwal Police Station. Full stop. Is it been registered?
My lord, my wife was there, my lord.
Ah.
Till date, it is not registered.
Full stop. You file an petition.
Yeah,
see,
now I'll file.
Ah.
them.
Registered, however, the same has not been registered. Be that as it may, considering the nature of allegation and the materials available on record, this court is of the view that petitioner has been able to make out a case for interim protection accordingly. The learned public prosecutor shall also obtain an instruction from the officer in charge Khatwal Police Station as regards lodging of FIR by the wife of the petitioner on 30/5/2024. Namely, wife of the petitioner, namely Rizwan. So what is the name?
Razmina Sultan.
Razmina Sultana.
I'll pay.
Within 10 days,
I'm deeply.
27.
27.
8,
May I please, Your Lordship?
Yes.
Lordship, POCSO 4, Your Lordship. Allegation, Your Lordship.
Notice. Where is the FIR?
FIR is case number 8, Your Lordship.
Are you pressing for an interim? No.
Lordship, case number 13 is the relevant process. Nowhere mention the age of the victim, Your Lordship. In
So
this
therefore
FIR.
interim.
No, actually, she has love affairs with my nephew, Your Lordship, and she visited my house with intent to marry him.
Case diary notice to the respondent number 2 in terms of suspensions.
25th.
25th.
9,
May I pray for this? Clear, please.
Earlier date you can pray, we can allow, but who will assure that notice is served?
15 years.
Tell us that. Yes, next case.
item number
May I please, Your Lordship? What is the section 4 is added here, Madam?
Item,
Item 9.
what is the FIR?
FIR is 9, Madam.
When? Same order, seven, in terms of notification 17.
10,
May I please, Your Lordship? For 38 application, Your Lordship. FIR is page 24, vernacular is 30, my lord.
Where are you apprehending?
My lord, I am apprehending whether there is two FIR
Hmm.
file. First one filed by the petitioner. His brother was killed by the complainant of the instant FIR. Thereafter, my lord, they filed this false FIR. And they are saying the false allegation in the FIR. Can you see, my lord? The 1,10,000.
Where is the other affair?
First FIR is page number, lordship, 13.
Page number
13,
13.
13. This is the FIR filed by the petitioner.
It was filed when?
It is filed 11/5/2024, same day, my lord. And 12/5,
It was registered as?
as FIR number 131, Mongoldev Police Case number 131,
What is
2024.
the- Who was arrested?
A complainant of the, all are arrested, my lord. Second, later on, my.
Where is
immediate-
the contents of the affair? Page, okay, page 19.
Page 19, my lord.
You are the informant in this. in
Yes,
this
I am
case.
the informant in this.
City interim.
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 Much,
Within 10 days appear.
27th,
27.
much of.
11,
For 38 application, my lord. FIR page 13, my lord, Bhavnagar location.
1.
13. In this case, my lord, for accused already your lordship has granted 3% in interim bail, my lord, and fixed on 18, my lord.
Already granted interim.
Interim, my lord.
Where is,
accused number 1, Lordship.
where is that? Let us see.
Page 11, Lordship. FIR. Who is the prime accused?
Page
11, Lordship, types copy of the FIR, Lordship. Entire allegation is against him only, Lordship.
My lord,
who is here? It is Bulal Sheikh.
Bulal is accused number 1.
and the accused number 3 is his wife, my lord.
Just a minute. Let us understand. Accused number 1.
Yes.
City.
My lord, maybe one thing, my lord. The accused number 3 is wife, my lord, and he was present in his house. I mean, how it possible, my lord?
That will see from the case that. How is it possible? Okay? Just remind us on the next. Yes, next case.
24th, Lordship.
On 18, my lord, because the co-accused diary has come on 18, my lord.
This date, next date is fixed on 18.
18.
Okay, on 18.
18, Lordship.
Of my lord.
motion number 12,
Yes, Mahajan.
Yeah, my lord, with all respect, my lord, primarily, my lord, no false promise. Assuming something is there, my lord, it would be a breach of promise, my lord. Then no criminality can be attributed. Only,
What
my
is
lord,
the stage?
stages, my lord, charges have been framed, my lord. May I come to the FIR, my lord, with all respect? my
Yes.
lord? That is, my lord, with all respect, my lord, at page 15, my lord,
1-5.
1-5, my lord. Second paragraph is important, my lord. May I read?
Mm.
I inform your honor that 1.5 years ago, the proprietor of the shop, namely so and so, this is the accused, my lord, before your lordships, proposed me for love affair. And I also agreed with the said proposal, wholeheartedly fell in love with him. Full stop, my lord. Meaning thereby, my lord, there was first love, my lord. My lord, with all respect, my lord, thereafter I continue, my lord. We were both in love deeply, and taking such advantage, he took me for travel to various places and had physical relationship with me by stating that he would marry me, and I became pregnant. Therefore, he gave me medicine and caused abortion. Therefore, whenever I asked him about marriage, he refused the same and misbehaved with me. He threatened me. Thereafter, finding no way, I submitted an application before the Lastit Gore Club, Amingao, for proper justice. And on the basis of the said application, a meeting was held in the club. But it is the matter of sorrow that Gourango Chakraborty refused to abide by the decision of the public and left the place. This is the affair, my lord. Thereafter, my lord, can I come to the 161 statement, my lord,
Yes,
that occurs at page 27, my lord.
heard Mr. B.K. Mahajan, learned counsel for the petitioner, also heard Mr. D. Das, learned additional public prosecutor. The present application is filed under section 482 of the Code of Criminal Procedure 1973, read with section 397/401 of the Code of Criminal Procedure, read with section so and so of the said code. Seeking quashment of the entire proceeding arising out of sessions case number 152/2023 under section 417/493/376/313/506 IPC. Full stop. Peruse the FIR as well as the statement of the victim recorded under section 164 CRPC. Apparently from perusal of the said statements as well as the FIR, this court is of the tentative view that no case under section 376, 417, 493, 313 and 506 has been made out. Full stop. উপরে লিখিব peruse needs further examination. I would say today. Hard so and so also peruse also. After perusal of the same, this court is of the view that this matter needs deeper consideration. Full stop. Tarpishat, after perusal of so and so, this accordingly, let a notice be issued, returnable on 28. Mr. Das accepts notice on behalf of the state. Any private respondent?
No, yes, sir, yes,
To
ma'am. Yes.
respondent number 2, to register post AD as well as the usual process, steps within 5 days. Considering in view of the, considering the matter in entirety, it is provided that till the next returnable date, the further proceeding of
My lord, Sessions case number, my lord, with all respect, my lord.
Sessions case number 152/2023 pending before the learned additional session just Kamrup Amingao shall remain.
Highly obliged.
Full stop.
Obliged.
Obliged. Call for the scan copies of the record as well as case diary of Swetcha.
My lord.
14 BA.
Yes.
Seated metal lordship. So POCSO has been added lordship. The victim age lordship at the time of incident lordship 17 years, 10 months, 1 day lordship.
Earlier rejected.
No, Lord. Not by this court.
Huh?
Not by this court, Lord. Trial
Yes.
court has rejected.
What is bail application 4000/2023? Yes. BA 4000/2023. Order dated 31/10/2023.
That I was not aware, Lordship. I did not check also, Lordship, because it's being a charge sheeted matter, Lordship, so that is.
4,000. Order dated 31/10/2023.
Sorry, Lordship, number was Lordship.
Hmm?
Number, Lordship, BA number.
4,000.
4,000/2023.
4,000.
Or after some time, Lordship, we'll check it out.
Action 15.
Make legal of.
Yes.
The 439 application, Malad,
Hmm.
in custody since 18/5.
Where is the
Lordship.
FIR?
Malad, FIR Lordship will find it page 13, Malad.
1-3.
One. Type copy of the FIR.
Here, man,
Today morning at 9 AM, the above mentioned.
charge sheet has been let down, man.
Charge sheet.
Charge sheet, man. Yes.
Oh, these police officers.
Both-
Toy gun.
Malad, it was a lighter actually.
Huh?
It was a lighter.
Anyway. Charge sheet file, we are giving you liberty to.
Hello.
BA, charge sheet being
24, dated 31/5/2024.
Both are similar. 15.
both are same, 15 and 16. Yeah, this case that reminds me of Three Idiots. To go to school, you need but on uniform. That's all. Now here to extort money, you need one uniform and one toy gun.
All right.
Bail was filed here. Then it was closed. Yes, Munir. Earlier bail was filed. It was closed because charge sheet was filed.
Just now I have checked. And
So I think
direction
this
was
matter
there,
will go
Lordship,
to that
approach
bench.
the jurisdiction.
It is submitted that earlier this petitioner approached this court by filing BA number 4000/2023. However, said bail application was closed. Closed as in the meantime charge sheet was filed. But it was not decided as such.
Just simply said, Lordship, charge sheet was submitted, so approach the jurisdictional court, Lordship.
But you ought to made a
No,
statement.
that was not given instruction, Lordship, and
No, that is
our
that is
fault is
correct
that we have
because
not checked it out, Lordship. My fault is that, Lordship.
that you will have to
No,
check it out.
I
Because
admit it.
otherwise this is a difficult proposition.
No, I admit that, Lordship, it was my fault, Lordship. I did not check the, Lordship.
Registry to verify and list this matter before the appropriate bench.
Lordship, I'm sorry, Lordship.
No issue, no issue.
Much obliged.
On next date on
List you will list it, madam.
I'm sorry, Lordship. Much obliged, Lordship. Much obliged.
Tuesday. We'll see, we'll have a talk. If necessary, it will come before dismiss. No problem on that. Yes.
52 supplementary list.
Yes.
Kindly pass over the matter for timely. In this case, we have filed our affidavit, Lordship.
If you file a affidavit, we'll proceed. That's all. Item number? Kyle is very busy. But you prepare yourself. We'll have it after some time.
Lordship, I am prepared, Lordship.
You are prepared. Okay, fine.
But my submission will be incomplete, Lordship.
Why?
My submission will be incomplete, Lordship.
Why incomplete?
It will not be sufficient, Lordship,
Why?
because
You have an affidavit. Think of one thing. We may accept, we may reject his bail prayer. But for you, the person should not be inside jail for a day. Suppose we allow it, is not it? Suppose tomorrow we allow it. Everybody is ready today. One day he will be inside jail for us, for you, for me. If you don't allow, no problem. We do not know what we will do. So this is very important right of a person. We may reject it. But if we allow, this will be a difficult proposition. He will be on illegal detention for one day. After some time, go to it.
Lordship,
Yes. Same. Okay.
much of it.
17.
That's it, Lordship.
Yes.
My lord, in this case, my lord, the petitioner is interim for last 1 year, my lord, from 15/6/2023.
Charge sheet has been submitted, Lordship.
Charge sheet submitted. Interim is there. Charge sheet being
365/23 dated 3/10/23.
3/10/2020. Dispose of.
Interim order extended, my lord, till then.
Yes.
Lordship declared.
Yes, Mr.
19 also,
Sinha.
Lordship, charge sheet submitted.
Any interim?
No interim.
No
No interim. You go there, approach. We'll give you a liberty to approach. Charge sheet being
705 dated 22/12/23.
no interim. Huh?
20.
20, Lordship, petitioner is an interim and CD has not been received.
CD not received. When?
28, Lordship.
As per my knowledge, Lordship, charge sheet has already been submitted, Lordship. So matter may come up on Monday for
Charge sheet
instruction.
submitted. Can you have the instruction?
Yes, Lordship.
Huh?
After some time.
After some time.
21.
Just have the number of the charge sheet. 20. Yes.
Also, in this matter, the informant has evident appearance and they have filed a affidavit wherein they have stated now the real fact of the case where it was actually a monetary dispute and they have settled the matter for 1,80,000 and the money receipt has been attached to it at annexure 20. And also,
Then we'll proceed against this informant. Where is the council? Is that it? There must be a warning bell for misuse of an offense. Where is the counsel for the other side? Malicious prosecution. Register a case and proceed.
Lordship, he may be allowed to go on.
Huh?
He may be allowed to go and bail your Lordship in this case because he is innocent.
No, we'll allow him to, but what, some action should be against the informant.
Yes. Direction is discussed in this.
Who is for the respondent? Bring him. Who is the law counsel? Name, sir?
R. Begum, Lordship. Yes, name is shown.
Where is the affidavit?
Phone number to open.
Affidavit, your Lordship, at page 18.
Yes, what is to be done?
Lordship, let-
First of all, mother cannot compromise on behalf of the minor, the alleged rape victim. And she has taken a specific stand against you under 164. So bail will be rejected, no doubt about that. And now what action? Yes, Mr. Ahmed, come forward. Tell us what is to be done. FIR allegation of rape by mother. She is a minor of class 8 student.
4 of POXO.
Huh?
4 of
4 of
POXO.
POXO. Then her statement recorded under 164, allegation of rape. Now mother says that on the instigation of the neighbors, I have filed this FIR. There are some misunderstanding and I don't have any objection granting bail. So either this man has influenced witnesses and she cannot, mother cannot withdraw her, give consent or compromise on behalf of the victim when it is a sexual offense. She cannot compromise, and that too in his case. So that is fine, but how to proceed? Because this act is also misused, no doubt about this. At the same time, there may be some influence on this lady by this man. Now, what course of action should we take against this allegation and counter allegation?
Video Lordship can expect to conduct.
Direction to whom?
Investigate. That also submit.
So the custodial intervention is very much essential now in view of this affidavit.
Also, he has nothing to do in this matter. This has been filed by the other side. And matter has been settled between the two
Settlement
parties.
is a settlement between you and the,
Actually, the real fact was also being stated in the petition. It was a monetary dispute between two friends. And 1,80,000 has been. settled.
we'll straightway not disbelieve this minor of class 8 student. Had it been a major, that would have been different. And that to a statement before a magistrate.
Then the lordship can call for the personal appearance of this informant.
Where is the council? And we'll refer the matter to the bar council.
Present.
The council cannot be do like this. This is a misconduct.
Take the matter after some time. I will give a.
Inform. Otherwise, we'll refer the matter to the bar council. As simple as that. For misconduct.
Item 23.
Is your lordship?
Yes.
Lordship, 438 application, my lord.
Steps taken.
Yes, lordship, I have taken steps, lordship.
Service is complete.
Lordship, I have not gone through the office of. In the FIR, page number 10.
Any interim?
No, my lord, no entry.
Where is the FIR?
Lordship, page number 10, my lord. May I read, my lord? Respectful submission is that I was in a love relationship with the below mentioned accused person since last 3 months. And on 3/10/2023, the accused person came to elope with me to
Don't
marry
read this kind of English. Go to the.
to marry me. Lordship. It is purely a adolescent romantic relationship, my lord. There, the accused person took me to his maternal aunt's home and kept my sister
Just
at
let us read the vernacular.
lordship. Page number 14, my lord. সন্মানপূৰ্বক বিনীত নিবেদন এই যে যোৱা 3 মাহ মানৰ পৰা নিম্নলিখিত পদকীয়াজনৰ লগত মোৰ প্ৰেমৰ সম্পৰ্কত আছিল আৰু 3/10/2023 তাৰিখে
Though
মোক
steps
পদকীয়া
was taken through registered post with AD upon the respondent number 2, comma. no AD card has been received back by the registry. First up, in view of the aforesaid fact, the learned counsel for the petitioner prays for and is granted 3 days time, is granted permission to take steps upon respondent number two in terms of notification number 17 dated 13/5, 15/3, 2024. Full stop. Accordingly, list this matter on. Yes, there is a seat.
May I read some interim protection, my lord?
Why interim protection?
Lordship, Lordship.
We
may-
cannot give you absolute, but we can absolutely dismiss it if the statements are there. Then we will not even issue the notice to the respondent. What is the age of the victim?
Date,
17.
date of
And
birth
what
is
is the age of the accused?
Lordship, accused is 19 years, my lord.
1/1/2006.
Uh-huh.
Date of birth is 1/1/2006.
Then 2006 is, 80. Third. You are Mr.
MM Zaman, lord.
M.N. Jaman, উপর লিখিবা, learned counsel for the petitioner. উপর কি লিখিবা, notices, steps to দিলে না? First of all, steps to be taken, so second লিখিবা. Mr. B. Sharma, learned counsel for the petitioner, submits that case diary has been received. Full stop. Peruse the same. Considering the statement of the victim girl recorded under section 164 CRPC. Also considering the age of the victim as well as the age of the present petitioner. That is present petitioner, which is 18 and 19 respectively. Till the completion of service, the petitioner is granted interim protection. লিখিবার বাকি।
Two petitioners, my lord.
Petitioner. Full stop. Appear before within 10 days. Okay. And case diary be returned back and be produced on
28.
28. Appear before that.
Highly on this, lordship.
24.
24 lordship, petitioner is an interim and CD not received lordship.
She did not receive.
28 lordship.
28. Interim to continue.
25.
25 lordship, can it be after a few minutes lordship? CD is available lordship.
Notice issued upon the respondent number 2, whether which notice there I have not.
Steps upon the respondent number 2 was issued. A notice to the respondent number 2, not steps, issued on 17/5/2024 through the office of the public prosecutor. Full stop. Mr. B. Sharma, learned additional public prosecutor, submits that he may be granted. Which time? Which time?
City come.
CD is there.
CD is there lordship.
Any case for interim?
No lordship.
No.
Maintainability is also under question lordship.
Why?
Also because it's an application under.
Okay, after some time you want to go through it?
Yes, yes.
Yes, go through it.
6.
Yes. What
Scan
hap-
copy is received, my lord.
Huh?
Scan copy is received.
Yes, what is your
Eh,
case?
Your lordship, my senior is on his legs, he's on the
Who
court.
is your senior?
PP Mehdi, your lordship.
Huh?
PP Mehdi, your lordship. He is on the way. That's for time being.
On the prayer of the learned counsel for the petitioner, list this matter on Monday. Any interim?
No,
No, my lord.
Monday?
Sir, seated matter.
Sunset, okay, Monday.
much obliged.
You have gone through it?
Yes.
Monday, because today we have a division bench also, we do not.
27.
CD not. 27 CD not received, my lord. He not interim, my
We
lord.
did not receive on
On
interim
interim.
and when?
On 24th, my lord.
24th. Interim to continue.
28.
28 CD আছে রে। CD আছে, CD আছে।
None appears for the petitioner on call. No steps for issuance of notice upon respondent number 2 has also been
Here
taken.
also, my lord, a issue of maintainability is there, my lord.
Why?
Lordship, may I kindly RPC, my lord. 430, section 438, no.
What are the offenses here?
Here 376
376(3).
no.
That's why.
Yes, my that's my lord.
I think these people might have been arrested.
May I
They have not taken.
four 38 section 4, my lord.
CRPC.
Not
4.
438, my lord. Subsection 4.
38 subsection 4. 3, 4.
Yes, last section, ma'am. Nothing in this section shall apply to any case involving in the arrest of any person on accusation of having committed an offense under subsection 3 of section 376 AB, DA, DB.
IPC.
No,
Penal code.
because of the age. It carries a punishment for life.
Now,
Yes.
what is the relevance of 376(3) when Special Act is there?
Yes. Anyways, special act will prevail, my lord,
Ah,
in this. But sections.
now whether there is any bar under POXO Act for anticipatory bail?
Here also,
No,
Because-
no.
yes.
So how will you read with these two provisions?
Yes. But if my two sections are there, then generally, my lord, as per.
Special
Special
Act,
Act, yes.
there is no bar under the Special Act.
Yes.
And what is the relevance of this 376 was incorporated when?
That it is later, much later than my lord. After the POXO.
Then I'm not getting anything. Where a committed rape on a woman
Not
under 6 years of age,
under
16 years of
16
age.
years of age. my
So
lord.
moment she is below 16 years of age,
Then-
she is covered, her right is covered or offenses are under POXO Act.
Lord, That is also, I am just checking at your lordship's guideline.
That's why
Yes.
I have opened this book because this
Yes.
question has come. What is the
Because-
relevance now?
There is, my lord, in the section 5.
So then we'll have to read that in any POXO, any case of penetrative sex under POXO, no anticipatory bail lies. What is the law in this regard?
Because,
Go through it.
yes, my lord. There is a case of 12 years, it is there, my lord, in a POXO.
Huh? What it says POXO?
Not regarding bail, my lord, it is regarding aggravated committed on 12 years.
So
Yes,
this
I will-
offense will be relatable to section 6 or 4.
Yes. This will be, 4.
376 to relatable to 4.
my lord.
20 years there also.
Yes, 20 years there,
20 years also, and below 16 years.
below 16 years, my lord,
Uh,
below 16 years.
so therefore, what will be the intent of the legislature? And how will you read it? We'll read it in a manner considering the right of a person.
Lordship,
Then suppose there is a allegation that a woman below the 16 years of age is raped, then what offense police will register? It is a cognizable offense under POXO Act.
yes.
So only registering, then what will be the meaning of the 376
Then
3?
again, my lord, 438 was, will be there, my lord.
So
Yes.
you clarify us.
Yes, yes, I like this.
That's why I brought the book.
Yes,
None appears for the petitioner on call. No steps for issuance of notice upon the respondent has also been taken. In view of the above, the present application stand dismissed for non-prosecution. This is your item number?
item number, my lord, this is 28.
Yes.
Dismissed, lord.
29.
My lord, we have taken steps while service is awaited, my lord. Send service.
We'll request the public prosecutors, whenever these bail applications are there, AB or whatsoever, just tell us that there should be a date, that one date should be fixed, maybe after 3 weeks, because this is now a mandate. In most of these cases, dates are not fixed. So even if after it is fixed, it is prerogative of the court or your convenience or but it should, their date should be fixed. Okay. Now steps upon whom?
Yes.
The notice to the respondent number 2 was issued through in terms of the notification dated notification number 17 dated so and so on 16/5/2024. Full stop. In view of the aforesaid, Mr. B. Sharma, learned additional public prosecutor, pressed for and is granted
1 week.
1 week's time to obtain a report from the concerned police station as regards status of service upon the respondent number 2. List this matter on 13th.
Must oblige, my lord.
31.
My lord, with due respect, can it be 14, my lord?
14th.
Must oblige, my lord. 14.
Yes.
31.
See, FIR is in page number 8.
No steps was taken on here. 25 notice was issued in this case same on
Yes.
25/2024. Then MP Goswami press for time in place of B Sharma, it will be MP Goswami and date will be same. Concerned police station. Okay. And case diary is there?
Case there is there, my lord.
If there is there, then you can see. If no case is made out, why
Yes.
should we issue notice?
Yes.
Isn't it? And if some cases are made out, we'll give an interim and
Case is made out. my lord.
Made out.
Yes, my lord.
Made out.
Yes,
So
my
dismiss it.
lord.
Okay, এগুলা লিখার দরকার নেই। Case diary is produced. Just let us see.
One sec.
See an application under so and so, so and so. First up, peruse the case diary. Case, also the statement of the victim. Minor recorded under, statement of the minor victim. Recorded under 164 CRPC. Full stop.
Here is also a case, my lord, below 16 years.
Hmm.
So that's, but it is not registered under
Uh-huh.
376.
Also, peruse the statements of the other witnesses and the medical report. Full stop. The aforesaid material clearly implicates the petitioner in aforesaid materials clearly suggest, will not say clearly implicate, clearly suggest the role of the petitioner in commission of the crime. In view of the aforesaid, this court finds no merit in this petition. Accordingly, same stands dismissed. The case diary will return back.
32.
May it read, my lord.
Yes.
My lord, although the CD is not available, my interim prayer may be considered as of now. As because I am the owner of the vehicle which has been seized in connection with the Khetri PS case number 60 of 24. For the allegation that has been stated in the FIR at page number 14, my lord. Towards the last portion, my lord, of the FIR at page number 14, annexure B. After interrogation, we came to know that the said cows were being taken to Meghalaya from Sibsagar for selling to the slaughterhouse at Meghalaya. In this incident, the owner of the cow and the owner of the vehicle are suspected to be involved. Now, one of the co-owners have already been granted bail by this honorable court. on
Bail means AB or BA.
BA, my lord.
Then
Court
you
has-
want a parity? We can right now grant you the parity.
My lord.
Surrender and come back. CD is there.
CD is not there, my lord.
Let him appear, let him explain what is, where are the cattles?
Said
This is not,
cattle
this
truck,
is not a case for custodial interview. Heard, so and so, so and so. The case diary was called by this court under its order dated 20/05/2024.
Khetri PS.
Huh?
Khetri, my lord.
Okay. Case diary is not received. Full stop. The learned counsel for the petitioner has praised counsel for the petitioner praised for an interim protection. He argues that the petitioner is no way involved in this case in as much as the prosecuting agency only suspects their role. Full stop. He further submits that the petitioner is the owner of the vehicle and he was not present on the place of occurrence at the relevant point of time. Full stop. Considering the nature of allegation, next paragraph, considering the nature of allegation leveled in the FIR against the present petitioner and the nature of offense, this court is of the view that interest of justice will be served if the petitioner is protected for the time being till the receipt of the case diary and a direction is issued to him to appear before the IO and uh, and IO to facilitate the IO to record the statement of this person. Accordingly, in the interim, it is provided that so and so, so and so.
25th.
25th.
Obliged, my lord.
Union list. 33, Union of India.
What is this?
Well, not a FIR lordship is at page 7. And lordship is, yes, there was one for the earlier occasion. Regarding lordship theft of OPR, it is the railway property.
Who will appear? Para sir?
The Union of India, my.
Railway.
Motion.
Name soon, name soon.
City Corporation.
Deputy SGI.
My lord, perhaps some other person has appeared earlier, my lord. I see the.
CD fund now.
Deputy SGI. Just have the instruction. We'll fix it on next week.
My lord, my lord.
Uh,
No, no,
who is there? Tell us. Registry to list this
No, no,
matter.
my lord, I'll take instruction. my lord. Some maybe,
Showing
maybe.
name of Mr. Parasar, learned CGSC
CGC.
on
On 13, my lord.
13th.
Obliged.
Timing attempt 20.
Yeah. Yes. Yes, there is received.
No.
Yes, there is not received. When?
Let. 19, my lord.
19th, interim to continue. There is an interim order. You can give a letter date also.
Then. Okay, my lord, it will come.
Okay.
For order item number 34.
Yes, Mr. Saikya.
But here I am appearing as a legal aid counsel.
Okay. What are the offense and what is the conviction and sentence?
365
Huh?
IPC, 365 IPC and section 4 of the.
Where is the statement? Who is the victim? PW1? Huh?
That. PW1 is number 8.
I think 20 lordship.
Hmm.
Charge sheet is submitted. Lordship will ask me to.
Okay,
take the
okay,
instruction.
okay. So, interim is just charge sheet submitted. Being charge sheet number?
24/2024 dated 29/4/24.
Now I recall. Yes. The petitioner's counsel says that charge sheet has been just okay. What was the age of the victim?
16 years at the time of deposition, and then
At the time of commission of offense?
minor commission. Yes, I'm checking. 15 years, my lord.
And what is the age of this accused?
No.
23.
Can you check?
Page number 20.
Age 20.
20.
Is it about 22 years?
Any medical?
Yes, ma'am.
Where is that?
The certificate, page number 62.
Hmm, 62.
62.
Even point number 9, 10,
Hmm. Page.
62, my lord. 9, my lord. Point number 9, my lord. And again, my lord, point number 10, my lord.
But how do you, what you say about this?
Age, radiological age.
Radiological age.
No, no, radiological, okay, fine.
Yeah.
Fine.
Birth certificate also.
What is serial number 2 opinion? Last opinion.
Lordship,
What is serial number 2?
post,
What is post? Any cross examination? Where is the evidence of this person? No cross examination.
post. Serial number 10 also it is there.
Serial number?
Injury is described.
Just a minute.
Something is missing, eligible manner.
Serial number 10.
10.
Page.
Page 62, madam, regarding medical.
Page, just a minute.
Yes.
Page 62.
Small such and such centimeter aberration and four,
Okay, okay,
four
okay, okay.
vaginal injury.
What is the law? In terms of, you'll have to, age determination is in terms of Juvenile Justice Act. So radiological things will come when others are not available. And time and again, it is settled that radiological test is not accurate. So therefore, even radiological tests are given benefit plus minus 2 years in many cases. So it may be 2 years either side. So that question will come only when it's a benefit is granted to a juvenile, not to an accused of 23 years. Okay, and that too, her certificate age, which is to be relied in case of an POXO,
But
and that determination is to be made under JJ Act, is that it?
JJ,
Section
if
90,
it is not there,
if it is not there.
Right.
So that is established. So that too, that is not a case for bail. That we can argue at the time of hearing. Pardon, Mr. Any IA is here, no? Why this matter is listed today?
Listed on orders.
Orders, why?
Earlier, there is another legal aid council is there. Court is on AFs and therefore.
Okay, okay, nine, okay. List is, we can decide today itself, but let us not go for that. After appointment of the new legal aid council in terms of this court's order dated 15/5/2024, the matter is listed, full stop. List is, as the matter is ready as regards service and service is ready, service na?
Service ballot.
informant to, party बनवा नहीं थे। party ना।
No notice to the present appeal is against a judgment and sentence passed by judgment sentence whereby the petitioner, the appellant was convicted under section 4 of the POXO Act. Full stop. In that view of the matter, a notice is required to be issued to the victim/informant. Full stop. However, no notice has been issued till date. Full stop. The present petition is being present appellant is being represented by Mr. Saikia Learned Legal Aid Council. Full stop. Accordingly, it is provided that steps for issuance of notice upon the victim/informant be taken in terms of the notification number 17 dated so and so and list this matter after 3 weeks.
Five.
Yes,
As per office date 3/6/24, LCR has not been received yet, Your Lordship. LCR has not been received yet.
Okay. This appeal was admitted when?
Admitted on Your Lordship, 2023, Your Lordship, 23/22.
Date of admission?
Just a moment, Your Lordship.
You see, IA.
29, yes, sir. I also took it.
IA te likha. Appeal, give the appeal.
Right, to
Respondent
case number
R2.
two.
Full stop. The present appeal. No record is called for. From where else here will come?
What is been called for?
First appeal.
Order it at 8/5/2024.
8/5.
2024.
There is no 8/5 order here in the appeal memo.
8/5/24.
There is a 9/8/2023.
Probably the
Probably in
order was
IA,
in the
probably in
IA.
the IA, my lord.
Can an order be passed in IA to admit an appeal? 8/5.
8/5.
8/5.
Last line.
Record is called for in an order in
Yes.
IA.
Yes.
Where is the order of admission of an appeal where a person has been convicted? Appellate likha. The present appeal is filed under section 374(2) so and so against so and so so and so so and so. Though this course under its order dated though a coordinate bench under its order dated 9/8/2023 issued notice to the respondents, and the respondents are duly being represented, comma, the appeal is yet to be admitted. Full stop. Admit this appeal. Call for the record. Full stop. No formal notice need be issued as the parties are duly represented. Duly represented. Full stop. Please this matter after receipt of LCR.
36 to 37.
Yes,
Your lordship may kindly recollect.
your luck is bad. Today is we are sitting in second half in the division bench. This is the matter.
Yes. And the place.
We have fixed it because we have taken a call to
No.
take up the other NDPS matter also today. All are adjourned. Only you are left.
I am left with 37. But my issue is something else, lordship. Here, lordship, I am in custody for today 728 days. And here, what has happened when I am before a lordship? From me, recollection was recovery as LS was 1.180 grams. But I have been convicted under 21B2C. So 21B2C says commercial, but there is no 29. So commercial is not there. Then if your lordship recollect, I took your lordship to the evidences already. And then it was shown that the evidences are so contradictory that there is no evidence to prove the recovery. Therefore, lordship was of the view that why not, if there is no recovery at all, then why not the 37 item also get the benefit, which
Let us do one thing.
Okay.
Let us do one thing. Let it be for the time being. We hope that after rising of the division bench,
lordship,
will be possible to come back.
lordship.
Then we'll take up. Otherwise, if not possible, then we'll take this matter on Tuesday
Tuesday, no.
or tomorrow.
Tuesday,
Tomorrow.
tomorrow.
Tomorrow we'll take this some tomorrow. Okay, or let us take this matter tomorrow.
Tomorrow.
Okay. List this matter tomorrow in the orders column. We'll take, just remind me, so we'll take up this matter.
Development.
58.
Yes, Mr. Pathak.
Under section 314, my lord.
LCR received
4 years conviction.
4 years.
4 years conviction.
Under
314.
third, Mr. G. Pathak. Ayat Likilo, Learned Counsel for the petition. The present application is filed under section 389 CRPC for suspension of sentence dated 21/2024 passed by the learned session judge, Kamrup, Amingao in sessions case number 126/2004. Full stop. Full stop. Peruse the appeal memo as well as the grounds taken in the present application.
Previous bill also.
Huh?
He was on previous bill.
Full stop. It is also on record that petitioner is petitioner is enjoying the privilege of grant of bail by the learned court below till now. Full stop. From the perusal of the material, this court is of the view that the petitioner has make out the case for grant of bail.
29/7/2011 Russell Bill too.
Full stop.
Previous bill.
This court is also of the view that there is no immediate likelihood of.
It is below.
Is in jail?
She is in jail.
Okay, okay. Motherline to know. Okay, motherline to know. Full stop. On previous bill na lagi. Because
29/7/11 to bail আছে লাগি।
okay.
It is conviction. আচ্ছা conviction উল্টা conviction না conviction এর বিষয় জেলও আছে নাকি কিছু না
She is in jail.
ঠিক আছে ঠিক আছে
Also peruse the contradictions of the evidence of PW6 which suggests that the said PW6, that is the investigating officer, during the investigation even did not collect any sample of medicine which was alleged to be administered to the deceased. Full stop. Also peruse the statement of the PW5. Which suggests that accused was reluctant to give the alleged herbal medicine to the deceased. Full stop. Considering the matter in entirety, this court is of the view that during pendency of the present appeal, the petitioner has been able to make out a case for grant of bail accordingly. Allowed to the satisfaction of who convicted you? Learned session judge Kamrup Amingao. Huh?
Amingao.
With following conditions. Full stop. The learned session judge shall be at liberty to add any condition which this court may wish. Dispose. I dispose. Yes, Mr. Goswami. See, we initially thought that we'll dispose of this matter, but that's why there is a delay in this order. We are not disposing it of. What happened to your examination?
My lord, he has been examined.
Now see, you have taken a very detailed stand as regards some appointing some Pairavi officers, whatnot. But every day we are facing that your prosecution witnesses are not appearing before the court. So therefore, what was the yesterday's matter?
And it is my item number 8.
Yesterday's item number 8.
Though my petition is not before me, but I somehow recall that. Yes.
21/6, is not it? This matter is directed to be listed on 20. So our view is that we want a report from the Assistant Inspector General of Police. How many these Pairavi officers are appointed or introduced throughout Assam?
No.
And what is your assessment as regard their effectiveness in dealing with this case? Yeah, all these cases. And third is, we are fixing this matter, bail application 44 of 2024. And another matter was there where Mr. H.R. Chaudhary appeared in this case. In the NDPS Karimganj Silchar case.
Yes.
We want to take all this matter along with this, and whenever these cases, this type of cases will come, we'll ask your Pairabis, what are they doing?
Well, can I?
Yes.
Can I? My lordship,
Yes, yes,
our-
you add it and you assist us.
My lordship, we have seen your lordship operative part of the order, my lord. We have looked into it, great, my lord. Only one thing that comes to my mind, my
Yes,
lord.
tell us.
Lordship, one query with this Pairavi officer concept of Assam police, my lord. When it was started, they need to bring this case within its ambit or not, my lord.
Okay, okay.
Then
that
the
is
Pairavi officer would be hold up, my lord. Because on 18 days.
now it looks, they have said that we have written it, the concept of Pairavi officers are in, see, we have written it. The Assistant Inspector General Police Law Assam has submitted a report, the salient features of which can be recorded herein below.
My lord.
All OCs of police station and all ICs of outpost of Assam have functional GOPT email ID. And e-summon can be served upon concern. Okay, this is welcome
right.
because under the new act that is already there.
Yes.
Disciplinary action against the police personnel
Exactly,
who
my lord.
deliberately fails to respond to a summon and do not appear in the court on account of negligence or willful disobedience of summons are being taken
If my-
according to them.
If, my lord, this Pairavi officer was working, it would not have happened for on 18
Yes.
days, my lord.
Now they say that so this is we have recorded the concept of Pairavi officers are introduced in the state of Assam and their roles are stated to be such officer is the link between senior officers, the PP, APP and prosecution witnesses. The Pairavi officers is to brief the PP, APP about the facts and circumstances of the case, about availability of a witness, and such Pairavi officer provides all facilities to the witness. They have to keep a close contact with IO on the progress of the trial of the case. Many other details are given in the said such role of the Pairavi officers. In view of the aforesaid, the court, while appreciating appointment, introduction of such Pairavi officer, would like to observe that in the present case, its first facilities were available. Either they have not been properly implemented
Exactly.
or there is a failure on the part of the prosecution, inasmuch as prosecution witness did not appear before the learned court below from 18/7/2022 till 30/3/2024.
Perfectly all.
This court can also take judicial notice that similar situations are there in many other cases, more particularly in the NDPS trials where prosecution's witnesses are not turning up on the date fixed for deposition.
Right.
Now it has become a common phenomenon seeking bail on the ground of delay in trial and resultant violation of the right of the accused guaranteed under Article 21 of the Constitution of India. In the aforesaid paragraph, this court would like to have a detailed report from the respondent state, more particularly from Assistant Inspector General of Police, Law in Assam, Guwahati, on the following counts. Suggest us, what should be?
My lord, whether it should be one Pairavi officer per district or not.
So that is, I'm saying, as regards how many Pairavi officers are
Exactly.
appointed, introduced throughout Assam.
Whether PP, my lord, ask my friend, my lord, who is, because it is, that has been submitted on paper, my lord, whether he is aware of Pairavi officer or not, the specific, my lord.
Now, yes, Mr. Goswami, don't take it to be an adversarial litigation. Tell us what kind of information we should have.
My senior is absent, my lord, regarding my lord Makon. When he come, my lord, I will take the
We are
details.
fixing it on 21st.
Yes.
Mine.
On 21st. And Mr. Mahajan just suggest us, it is one aspect. What should be the other aspect?
First one is, my lord, whether per district one Pairavi officer or not. Otherwise, it would be pointless, my lord. There has to be area wise, it has to be demarcated, my lord.
Okay, then.
Number one, my lord. Secondly, my lord, there is one line in your lordship's order that to coordinate with the public prosecutors, whether, because if it has been implemented from a particular date, whereas they have, with all respect, my lord, coordinated with the PPs or not. No PP is aware of it, my lord. I have asked personally.
So therefore, we want the details and their effectiveness and all.
Exactly.
Now, we, on the next stage, we'll have already in one case, we have asked the registry to give a report so far relating to the pendency of NDPS cases.
My lord.
Because these NDPS cases is in terms of section,
Article 20.
no, 36 or
Exactly.
something,
Yes.
where it is it should be dealt with by a special court.
Absolutely.
So, if a district judge is designated as a special court, now he will have to take a succession case
My lord.
from a first appeal,
I have understood.
isn't
my
it?
lord.
So he will take everything. Even in some cases, he is also a special judge of POCSO, special judge of NDPS.
Too many special judges. in-
So,
vested in one
there is
court,
no
my lord.
meaning of having a
Absolutely.
section 36A has or something. What was the section 36?
Yes.
Has been defeated.
Right.
So we have called for a report from the registry in
So
other
my
case.
court is
So
created
I
for
will
NDPS.
take this matter along with them,
Yes,
that
yes.
also.
Yes.
That what is
Well,
that case?
Per district, that may be lordship may
Okay,
seek
per
specific.
district.
Per district and whether my
Or
lord.
per district or court wise,
Court,
because there
exactly.
may be
Yes, yes.
there may be necessity in sessions division
Yes.
or in a CGMs,
Yes, yes. Lordship is very correct.
magistrate division.
I both, my lord, together.
Ah.
Conjunctive, my lord. And secondly, my lord, from when it was implemented, whether PPs are aware of it, my lord, no coordination possibly, my lord.
The other case is of last week's, my lord.
Last
Remember?
week, last
Yes,
week.
last week. Just,
And
there also some report has been called.
since we cannot have that data, how many cases, what is the delay in prosecution? We cannot have that
No,
data
no,
so
yes,
easily.
yes.
So therefore, we are taking 2-3 cases where this kind of
Their lordship
things are
assumption has
there.
been wrong.
Oh.
Yes, I have understood.
Yes.
Yes,
So
yes.
we'll take this.
Number, madam.
It's just give those
I-
numbers, we'll fix all these cases. And I have kept it as a part heard.
Exactly, my lord. I was supposed to say that, my lord.
Yes.
Highly of that, sir.
Yes.
Highly of that.
We'll pass, I will just simply
yes.
modify this order. We are fixing it on 21st.
Their lordship has passed. Oh, sorry. Exactly. I have understood.
So because other cases
Yes,
are
yes,
just list
21.
along with so and so.
21.
We have already drafted this order, but we'll just modify
Yes.
regarding the, okay.
Highly of that, sir.
Registry to list, just modify, registry to list the name of Mr. M. Phukan, learned public prosecutor in this case.
Mine.
এটা বছর উঠি মাতিলে
Standing matches. Matching with 21.
Yes, yes. Yes. Yes, item 21,
Lordship, the,
that matter.
yes,
Where
the
is the petitioner gone now?
petitioner Lordship, he informed me Lordship that he had contacted with the respondent number 2, Council Appeal Protection, and he
The present application is filed seeking privilege of anticipatory bail by the petitioner in connection with Lanka PS case number 81/2024 registered under section 376 IPC, read with section 4 of the POCSO Act 2012. Full stop. The informant in the case is the mother of the victim, who is aged about 15 years.
Lordship.
Huh?
Lordship.
Who is aged about this? Full
Around
stop.
16 years, Lordship.
About who is aged about 16 years. Full stop. Notice is due to be circular. Come on. Notice was issued to the informant on 8/5/2024. Full stop. Where is he?
She is coming. She is unwell, so she has come from the home right now. She's
Full stop. Notice was duly served upon the said informant, and she is being duly represented by the he is duly being represented, full stop. Case diary is also produced, full stop. From the case diary. Yes, madam. What you want to say? Yes, what is your what you want to say?
Lordship, sorry for late. I have been filing this Okalatnama for their instruction, informant instruction. No, any objection?
Okay. Full stop. কি করলো? Case diary is also produced. Case diary reflects the statement of the victim has been recorded under section 164 CRPC. Full stop. The said statement reveals that the minor accused has specifically implicated the present petitioner in commission of the offense. However, surprisingly, the informant mother has filed an affidavit in this case. Inter alia, stating that the informant is no longer interested to proceed with the case in as much as, according to her, the such affair was lost due to some dispute, monetary dispute between the petitioner and the informant. Full stop. And such monetary dispute has been settled and payment of rupees 1,80,000 you have made her. Who made
The petitioner has made the
payment?
payment to
Okay.
the other.
And 1,80,000 has been paid to the informant. Full stop. Such affidavit was filed on 27/5/2024. Full stop. It is also her case. It is also the case of the informant that on the basis of the instigation of the locality, on the instigation of the people of our locality, she lost the affair. CD. The full certificate of the petitioner of the victim reveals that her date of birth is 23/7/2007. she has also been medically examined. Full stop. Her statement was recorded by the magistrate on 4/3/2024, and the affidavit has been filed on date two. Full stop. This court is of the view that uh, the victim also stated that such forceful act of the petitioner was witnessed by her brother. Full stop. And statement of the brother also fortifies such allegation. In view of the aforesaid, material, the informant's consent in the considered opinion of this case is cannot be a consent in the eyes of law for compromise of a offense, sexual offense / assault on a minor. Full stop. At the one hand, if such kind of situations or actions are allowed at the behest of the informant, not only such, there is probability of misuse of a criminal offense and on the other hand, there is possibility of withdrawal of such offenses on the basis of compromise entered by the parents when the actual sexual victims discloses the facts of commission of an offense. Law is by now well settled that courts can compound cases in exercise of power under section 320 of the Code of Criminal Procedure. However, law is equally well settled that this court, in exercise of its power under section 482 CRPC, can also quash criminal proceeding involving non-compoundable offences, considering fact and circumstances of each case, more particularly when disputes are civil in nature, and which is having no impact on the society at large. Full stop. Full stop. In the present case, the offense alleges are grave in nature and allegation is a rape on a minor. Full stop. Such allegation and criminal proceeding cannot be compromised. Full stop. In that view of the matter and in view of the material available, the bail application stands dismissed. Full stop. The IO shall investigate under what circumstances the affidavit has been filed and compromise has been entered into to compromise into. Full stop. There is possibility of the petitioner influencing the murder by paying money, in as much as admittedly an amount of rupees 1,80,000 has been paid to the informant. At the same time, there is also probability that the case was lost by the informant mother. There may also, not cancer, may also be possibility. Full stop. In that view of the matter, while closing this, dismissing this bail application, the IO is directed to investigate. So far, the relating to the filing of the filing of the so far relating to the compromise, alleged compromise between the parties. We'll add something there later on.
Genuineness of the affidavit.
Huh?
Genuineness of the affidavit.
Genuineness of the affidavit. That word will be good. Dismiss.
25.
My lord, here, my friend was under raised objection regarding mandatory of this petition. Because they said that as per clause 4, section 438, there is a complete bar to file anticipated bail applications. But so far as some decision of various courts, it held that it is not a complete bar. It can be, my lord, it is a little bit case wise. In our
Now, case there is there? Huh? Let us see the case there first. Then we'll go to this legal issues.
64, 161, both, malad, I have phlegma, malad, I go to both, malad.
What is the age of the victim?
Not
14 years, 14 years.
14 years. Why not act, the act not done, it is reflected in 161.
Now, why they have come before this court?
Malad,
Where is the FIR?
It's 18.
Yes?
18.
by name is given.
My name mentioned at serial number 3.
Now, how this name has come? Show us that.
Malad, that is also. Malad, I have.
I mentioned here, there is some cases pending.
Forget about some cases. Some cases will not save you from
Yes,
POXO and
yes,
376.
Girl, yes, not another, but and regarding telephone call, said that yes.
Why
Not
it will
receiving
give you
call.
mobile to call her? Hard. Mr. Swenso and Mr. Swenso. This is an application of the Swenso. Case diary is produced. Peruse the same. Peruse the statement of the victim girl recorded under section 161 CRPC, comma, her statement recorded under section 164 CRPC and the FIR. Full stop. The statement of the victim suggests that on the fateful night, 3 unknown persons forcefully took her to the to her backyard and outraged her modesty. Though
5%.
5% outraged her modesty. However, her statement further suggests that she could not identify this person and these persons are unknown to her. Similar stand was also similar facts was also stated before the investigating officer. And when her statement under 161 was recorded. Full stop. Interestingly, her statement further suggests that these 5 boys outraging her modesty and attempting to rape her handed over one mobile phone to her so that she can inform the fact to her parents. Accordingly, she had informed her parents. Full stop. There is nothing is discernible in the record as regards identification of this person by the accused, by the victim. However, in the FIR, these persons are named as victim.
Accused, name is accused.
Name as accused. Name as accused. Full stop. Considering the above, this court is of the view that the petitioner has been made out a case for grant of an interim protection. We are giving him interim. Full stop. Accordingly, it is provided that the petitioners, following is provided within 10 days. This is an interim order. Huh? In 10 days they will appear. Full stop. So and so. While it is further provided that the no, will not say anything. Full stop. Place this matter on.
For up to date CD.
Yes. Let us see.
At 25th.
25th. Case diary be returned back and be produced on the next date fixed.
I will agree. May I please proceed? Whether the applicability regarding the 376 AB, I'll go to the other decisions, madam. Just one section I want to refer, madam, there in the POCSO, section 31, madam, whether that would suffice, madam. Just I want to just.
What it says?
It says, madam, save as otherwise provided in this act, the provisions of CRPC, including the provisions as to bail and bonds, shall apply to the proceedings before a special court.
So
And
then if we go by that, then these offenses under POCSO are in no cases you can file for 38.
Yes.
See, we'll say that 37, suppose this is not a case of 376
then, my lord,
So it cannot
cannot be.
debar us saying that because of this bus will not grant a bail in a miscellaneous malicious petition, malicious allegation.
only the legal side, my whether.
That is where the beauty lies.
Lord.
Courts are interpreting
Yes.
the way it helps the right of the people under Article
Lord.
21. That's all. Yes, next case. Gimana, sir? Okay. Yes, Ahmed. Where is the FIR?
Page, starts from page 10, from complaint.
Page 10.
Page 10. And relevant portion, your lordship will find page 11. From other persons, it was recovered and it was from a guest house. I was in different place.
Where?
Paragraph 1, page 11, lordship may kindly see. It was recovered from house number 4, Anil Nagar, Guwahati.
So it was recovered from house number 4 Anil Nagar. Then
Page 12, first line, lordship may kindly see. Page 12, first paragraph. Last part of paragraph 2. Above your lordship will find two persons are named. Jongpa Hokip and last line.
Where? Jangpo Haukip.
And last line your lordship will find, on request the second person in the room introduce himself as Sri Paukhal Hokip.
Where? One Jangpo Haukip.
Yes.
His presence of and dear what is your name?
My name is Lordship.
Themboi.
It was recovered from them. And then they disclose my name, that portion your lordship will find, page 13.
Both the occupants. Who are these both occupants?
They are already arrested.
This Jangpo Haukip and where is the other name?
Page 13, first paragraph, last two line lordship will find. On the request, the second person in the room.
Themboi Singh son.
Lordship.
Okay. So these were arrested.
And
On the
page-
and
page
then what
13.
is your allegation against you?
Page 13.
Hmm.
The DRI officer in presence of the two occupants of the room searched the house but no further contraband. All the 88 recovered plastics were then again put in the said red trolley bag. On further inquiry by the DRI officer, Sri Jongpa Hokip informed the DRI officer that he, along with Sri Poklal Hokip and one lady, Srimati Themboi Simpson, this my name came, had brought the recovered heroin from Manipur, and the lady, Srimati Themboi Simpson, is presently staying in the room number 407 of Makamakhya Grand Hotel at Satribari.
Hmm.
So this present petitioner is staying at Satribari.
Hmm.
So this is how they connect.
Now what is recovered from you?
Nothing recovered from me.
Where is that? Where is your
Thereafter,
source?
the DRI officer decided to intercept the lady and buyer of the recovered.
Which
heroin.
paragraph?
That next paragraph, paragraph 4, page 13.
Next paragraph. Yes.
That thereafter the DRI officer decided to intercept the said lady and buyer of the recovered heroin and proceeded to Ma Kamakhya Grand Hotel along with the witnesses. The two intercepted persons who also carried the red trolley bag containing recovered heroin, upon reaching Ma Kamakhya Grand Hotel room number 407, was identified with the help of receptionist of the hotel. Two persons, one of whom was lady, were found in the said room, and on being asked by the DRI officer, the lady introduced herself as Srimati Themboi Simpson of Imphal, Manipur, and the other occupant person introduced himself as Sri Fakirul Islam of Mankasar, Assam.
Now what is the stage?
Now, lordship, the charge sheet they have filed, and
Witnesses, how many witnesses examined?
no witness examined.
Lordship, may I submit? Lordship, final complaint has been filed on 29/2/2024. So Lordship, the case is on appearance stage. Because Lordship, one of the accused person is absconding, accused number 5. So Lordship, this is the status, Lordship.
Now it
And
is to be
Lordship-
split up, isn't it?
Yep.
After 1st of July, it will be different. After 1st of July, trial in absentia. So wait for some time.
Nothing was recovered.
No, nothing was recovered, we understand. But there may be some other materials which can link you between. If there is nothing, we'll give you on it's a little bit early, according to me, with this quantity. We can adjourn it
But
to
lordship-
after vacation. At best.
Lordship judgment is there, which is.
No, our judgment is there. We understand. My concept is clear now. Though initial, see, if nothing is there only on the statement of co-accused
He accepted.
or the statement of the this what you call it, the accused itself, it cannot be. We will grant bail because not likelihood. But let us see. It is a little bit early. Suppose this is a statement of the co-accused. Okay, and that leads you to recovery. Then it is corroborated.
No, nothing was
No,
recovered.
we know that. Here it is nothing is recovered. In that case, you have little bit case is made out, but it is not a case at this stage.
But
What is your case?
Lordship, on 16/9/2023, her voluntary statement was recorded.
Hmm.
Lordship.
Now, what is the law as regard voluntary statement? Tell us that.
Lordship, she admitted and
No, she admitted we know, but what is the law declared by the Supreme Court as regard voluntary statement? One judgment says that not at all admissible. And other judgment says that it can even be applicable, that said principle will be applicable at the stage of bail. So until and unless you have any link between this statement corroborative, independent, that disclosure statement is corroborative any statement, nothing is admittedly you have nothing is recovered from that. What are your materials, proposed materials to convict this person? Tell us. The
Lordship,
voluntary statement of co-accused and him, there is no recovery.
Lordship, this is
Now,
the
how will you link it? If it is not admissible, it is not admissible.
Lordship,
Possession first, you'll have to prove the possession. Possession is from the other. If possession is proved, two persons can be convicted. Now, how will you convict it? Even you are not saying that they are linked, they are this, that, there are some phone connections. So I want to know what is the materials collected against this person.
Lordship, the trial is in the initial stage, Lordship.
No, trial is initial stage, but materials are before you. We will accept every material to be correct. Whatever you have collected, tell us that these are the materials on the basis of which a suspicion is created. Where is that? Except the voluntary statement. Except the voluntary statements to us.
Lordship, her husband is also involved.
Where is that? What is the materials against her husband? In your that investigating authority has collected.
Husband is not an accused in the present case.
Not in the present case, but he was involved in 2023, Lordship.
That may be made the husband an accused. Can you make a wife accused for the action of husband? Suppose you accept that her husband was involved. Can on that basis a person be convicted? Tell us. These are the only materials. Where is their petition?
Their initial complaint, page 10. Initial complaint, page 10, and final complaint at page 19.
Page 19. He can morally be convicted, see. That is for no doubt about that. Morally convicted. Page
19.
Let us see what is their statement against you.
Voluntary statement, you will see page 25.
Now, what are the materials they have collected? Annexer, they have given annexers, no?
That your lordship will find.
What are
Page
the
80.
Huh?
Page 80, those annexers.
Page 80?
Lot.
80.
80. List of documents.
Now, what will be the value of their statement, voluntary statement, in suppose the possession is proved?
Even then, also the coercive statement cannot.
No, forget about that. Their statement that we have carried it, voluntary statement, supported by recovery, then what is the value?
Oh, that recovery will remain to that part, to them.
That part of it. Yes, madam, give us something. Morally is something different, and
Lordship, my submission is the presently it is on appearances, so it should
no,
be
we are not on this delay in trial. We are on 37. According to him, the rigor of 37 cannot be applied on the basis of this material. We'll pass this order. We'll see.
kindly consider that objection.
That will record. There is no problem on that. But that will not end our job. We want proper assistance. Recording to no problem. We'll see. Dispose of. Dispose of. What? Which way will be disposed of? It will be later on.
Lordship, in this case, final complaint has been filed today, Lordship.
How many days?
57 days.
57,
80?
57 days.
57 days.
What is the period?
60 days.
60 days.
Final complaint has been filed today.
It is submitted by the Learned Council for DRI that final complaint, after completion of investigation, final complaint has been filed before the competent court. Full stop. Accordingly, the present application stands closed with a liberty to the petitioner to approach the Learned Court below, and in the event such application is filed, same be considered as part of the trial.
Citation laws is that compromise in POXO cases in bail matter. There are some directions issued by Honorable Apex Court, so at paragraph 44.
Give us that.
I have given, just here.
Okay, you keep that in the.
And the police may be directed.
That
because
we'll
part
follow
is there, Lord.
We'll follow that. Yes. Obliged.
Highly object.
For admission item number 13.
Same. Division bench, Lordship.
We'll try this matter after division bench is over. Okay.
If time permits, my lord.
If time permits. Yes, madam.
So Lordship,
Mm.
Lordship, in this matter, the respondent number 2,
Mm.
in a person, he himself has been appearing before this court, Your Honor.
Who are you then?
He's in the lobby, Lordship.
Let
May I
him-
call?
Of course, if he's in person, he will have to be here. What is this, Mr.?
My lord, a complaint petition was filed under section 499 and 500,
Okay,
claiming defamation, my lord.
okay, then.
So, my lord, 200 statements were recorded, then 202 further statements were recorded subsequently. As a court witness.
What is the complaint?
My lord, you will find at page 10.
Page 10.
My lord.
Yes, Mr. Dotto. Which is your item?
I'm 44, Lordship. So
44.
it's not possible, perhaps. My only difficulty is, Lordship, that it's stay is fixed for hearing, but stay was not refused, but it was not considered. Now I am taking every date I have to appear before the court and file an application. That hearing is pending before the High Court.
Okay, let us see if we can come back.
Lordship.
Yes, sir. Where is the complaint?
Page 10, my lord. It was, my lord, the allegation, date and place of occurrence, my lord. 5/2/2014, and
Page-
subsequent dates.
Page,
Page 10, my lord.
you take a seat. We'll come back to you.
Thank My lordship has got it.
Mm.
My lord, the date and place of occurrence is 5/2/2014 and other subsequent dates.
Mm.
Then it was filed on, my lord, 2/5/2014.
Yes.
After a lapse of almost 1 month, my lord. The basic allegation in this particular case is, my lordship will find at page 11, it starts from para 4, my lord.
Para 4.
My lord. The sequence of occurrence, my lord. Married. my lord.
Yes.
The opposite party came to the house of the complainant along with her husband, Sri Rakesh Kumar Paul, in the month of October 2003 during Durga Puja. The complainant celebrates, organizes Basanti Puja in the month of April and Durga Puja in the month of October, November every year at his home. The opposite party is a professional singer and she sings Hindi, Assamese and Bengali devotional songs. Therefore, the complainant requested the accused person to sing during both the occasions of puja at his house. The accused person since the year 2003 has been singing during both the pujas as stated above, bearing 2011 and 12. Even in the year 2013, she sang in Durga Puja organized by the complainant at his residence. Then, my lord, para 5, the accused person sang on the day of Astami Puja in the month of October 2013. After the guests and visitors left the place of puja at the residence of the complainant noticed that the accused person left the cover of her harmonium at the place of puja in her residence. After the puja days were over, the complainant went to the house of the accused person on 17/10/2013. This is important, my lord. On reaching her house, the accused person told the complainant that she intentionally left the cover of the harmonium at the residence of the accused person because she wanted that the complainant visits her place to return the same. The complainant could not quite understand what actually she meant by her this kind of statement. That on 18/10/2013, the accused person had spoken to the complainant and asked him whether he will be able to help her. The complainant, out of a good gesture, asked her about the help she is looking for, and she told about some matrimonial disputes. The accused person thereafter started calling the complainant 4 or 5 times a day, and all the time she had told how her husband, Sri Rakesh Kumar Paul, Chairman, Assam Public Service Commission, APSC, has been mentally and physically torturing her for a long time. Then, my lord, para 7, the complainant shared the problem of the accused person with her wife, and looking at the problems she had been undergoing, the complainant's wife told him to help the accused person. The accused person was able to
Who
draw.
defamed him?
This,
Who defamed this man?
my lord, Sunanda Paul.
Sunanda Paul has defamed him.
Defamed him.
Where is that? How it was defamed?
He, my lord, on para 8, he has stated, my lord, that at page 13.
Whose initial depositions were taken?
My lord, the complainant himself
And
his wife.
where is
and
the wife's statement?
My lordship will find that page 20, my lord.
What is page 16?
16, my lord, is the initial deposition,
Initial deposition.
my lordship. 16, my lord, the last 3 lines, my lord.
16 is the initial deposition.
16 is the initial
Then?
deposition. Then 20 is the 202 statement of the wife, my lord.
His wife.
His wife, my lord. She is hearsay, my lord. Page 21, my lord. 7th line. He started to make statements before her music society against my husband that he had taken a sum of rupees 47 lakh from her and also made marriage proposal to her. So this music society, she has stated, my lord, according to his wife, my lord. And this is important, my lord.
Who is CW2?
CW2 is his friend, my lord. At page 24. Page 25, my lord. Last 4 lines. One day, Sunanda told me that Rapti Baba took 47 lakh from her. And she also stated that some others, and as a result of Rapti Baba, business got hampered. So 47 lakhs, my lord. So now, my lord, page 28. Page 28 is important, my lord. He is one auto rickshaw driver, my lord.
Page
21, my lord.
21.
My lord.
21. She started to make statements before. This is the 21 is the Sonali Swami. Huh?
Page 28, sorry, my lord. Page
Tell her.
28, my lord. I'm sorry. He is one auto rickshaw driver, my lord. Last 3 lines, my lord. While I was talking to her, the accused, last 3 lines, my lord. The accused, Paul Madam, told me that complainant took a sum of 47 lakhs from her and he also gave her marriage proposal. Though I did not believe her, but I remained silent. Many persons inquired me, page 29, my lord. He does not believe her, so question of defamation does not come. But still, my lord, page 29.
Yes. What is the defamation? Let us understand.
I'm Rakshima Swami.
Hmm.
I'm the respondent number 2 in this particular case. So, Sunanda Pal was used to sing.
So these are facts. How the defamation is, what is defamation and how the case of defamation is made out from the complaint and the deposition. Tell us that.
First thing,
What do you understand by defamation and what is the offenses, whether it is made out? Forget about your story.
Okay.
Who has done what is not, we are not interested. We are interested in from the complaint and the statement made, a case for defamation is made out. Before that, you'll have to say us what is the defamation.
Under section 499 of IPC.
What it says, read it.
In IPC.
499, read it.
499 of IPC.
Yes.
Under where it was clearly stated, defines the defamation, whoever by words, either by spoken or intent to be read, or by any visible sign or any visible representation made, make or publishes any imputation concerning a person, to defame him, or knowing to be defamed, or believed to be, there is a reason to believe that it has this imputation to defame that person. And also such imputation would hurt the sentiment, emotion, and feelings of his family members or any near and dears, called the
It
defamation.
will be very difficult if we go by your proposition.
So, so the basic case is that her husband was a very big person, and she belongs to a high-profile
No,
political
no, we
family.
understand. Somebody said that you proposed her to marry. She had some difficulties in her married life. So she said that so and so has proposed me to marry and he has taken 47 left for me.
So it
And everybody says that these are wrong. These are so your reputation has not gone down in the eyes and estimations of your witnesses. Everybody believes, this is a false fact.
No, but
So your reputation is intact.
And the civic society, I was defamed. Even my business was totally collapsed because her husband was a PSA chairman.
Nothing material is available on that.
So,
the other person, a person is defamed in the eyes and esteems of others. A person is said to be defamed when for act of a person, your witness must say, I do not like this man. This is a man, because this is a man, he proposes a married lady. Therefore, I don't have any but your all witnesses say, no, I am happy. He is good. This lady is bad.
my submissions is that, sir. I want to.
No, that's why, because you are in person. See, two things. One thing is that we are not dart of cases, number one. Number two is that since you are petitioner in person, you are being given a little more time because you are not so aware of lawyers. But that will not mean that we will waste our judicial time. So you must be to the point.
Yes, sir.
It is your option. You have come on your own.
Yes, sir.
So according to us, your what you say reputation has not gone down in the eyes and esteems of the others.
May I add one more point?
That is an explanation 4. No imputation is said to harm a person's reputation unless that imputation directly or indirectly in the estimations of others lowers the moral or intellectual character of that person. Your witnesses, no one has said. Metarans there.
3 witnesses said.
That's all. That is the taking of cognizance.
Out of 8, and 10 years has been gone in this particular case. So,
therefore, it is the best time to dismiss this, allow this petition. Yes.
My lord. And this statement, my lord, nowhere it is stated that he is not returning the money. He has taken the money, my lord. In fact, his own witness has
that
caused
money has been
defamation, my lord, wherein the rickshawala has said it is not correct what she is saying. If it would have been correct, then the money that he had taken from me, he would have returned it. So if this statement would have had been my statement, then my lord, different.
So we'll not go to all these aspects here.
My lord.
Basic case is whether a case of defamation is made out.
So, my submission is that they have came to the High Court at very initial stage of the trial. They have not given. They have not given.
Because according to them, no case is made out, and we are convinced that no case is made out.
So what is the reason for delaying this process for last 10 years? I'm coming every time and I'm going
That's
back.
why we are deciding it today.
So
In this court, there will be no delay.
Even in the
Forget about those. What is happened is happened.
on Honorable Supreme Court has said in the initial stage, if you kill 10 years of time, that means you are influencing the witnesses. You can influence them by muscle power or manpower.
Statements have
It is
already been
happening.
recorded.
It is happening, and if I cannot get a chance to defend my case in the trial court, how we can establish that my allegations are true or false?
That procedure is there. When a case can be filed, when not, that answer we will not answer those questions. The question is, this is an application under 482. 482. This is a power. I'm still wasting time on you. This is a power where if there is no case is made out on the basis of the complaint and the initial depositions, we can quash it.
So give
Want
me
to add
5 minutes time. If
You want
allow
to
me
add,
5 minutes.
you want to add something?
Yes, sir.
You want to add something?
Because-
We'll come back. If we come back, we'll hear it, or otherwise we'll hear it tomorrow. You are from Guwahati?
Actually, I'm from Guwahati, but recently I've been shifted to Delhi. and
So
come
you
back-
are, you are here to argue this case?
Yes,
So
I-
if time permits, we'll hear it, otherwise you'll hear it tomorrow. Okay, because I'm having a division bench. Yes, Mr. Goswami,
I have a small prayer, my lord. I am appearing in episode 45. But today evening I have to leave for Delhi.
how all
Not
this
good.
not good,
Not good. He's slipping away.
stepping away?
Hmm.
Okay,
So
you
I-
need not, for that you
after
need
2
not
weeks,
come,
sir.
we'll adjourn it, after 2 weeks. After.
Item 45. my lord.
Yes, Yes.
Interim order, man. 45.
interim order to continue.
Leave no.
Yes,
Good.
give us updated.
Sure.
Yes. Anything, other matters, any urgency? Bhathakur?
An appeal, your lordship, he is behind bar, that's.
See, we'll try to come back if possible and sit. If not, then we'll give a date because there are, I think, 2 matters we have fixed. His matter, person and who is the other matters? Not.
Mr. Nath, M. Nath Smith.
I'm not matter will take time.
Let's
If-
see, Your Lordship, if it does not reach
For how many years of conviction?
10.
Then this LCR has come.
Yes, yes.
Objection file.
Everything is there.
What is the offense?
326.
32610.
10 years.
What to do?
I'm just-
We'll try. Yes, what is your
Next
next?
item, 41, my lord. The quashing matter.
Okay, who do not want to do their cases will give a date adjourned with interim order extended, and who want to do their cases take a chance in the second half. Because after division bench, that's all. Somebody be adjournment लगे दी थी. Yes.
The complainant of the complaint case.
Hmm.
They basically challenged the cognizance order, which was passed by the learned magistrate without obtaining the opinion of a medical board, independent medical board.
Hmm.
So that is definitely an infirmity.
Hmm.
On the last occasion, I had submitted that if the cognizance order is set aside,
Hmm.
and the matter is remanded to the learned trial court for proceeding in terms of the guidelines laid down in Jacob Matthews' case, then the complainant will also not have any grievance.
Lordship, my senior is arriving, he is coming.
Who is your senior?
And Decca, he is coming. Lordship.
Okay, Decca.
No.
Jacob Matthew. Okay, then some other day.
No, Lordship, it is disposed of because it's a 2019 matter. and
No,
then-
that is not a problem, but time will, so he is not here. Anyway, after some time, yes.
After some time.
May I say one thing?
Yes. Yes.
Lordship. No, my lord. Time didn't permit, my lord. That I wanted. I hold.
Yes, yes.
He is the person representing, my lord, the session court in the NDPS cases, my lord. So if
Who?
the lordship want to have some query, my lord, he can.
Okay.
He is additional PP in the session court.
NDPS.
Yes, lordship.
Why witnesses are not coming on behalf of the prosecution?
Which in most of the cases, the witnesses are official witnesses who were witnesses to the seizure. And most of these bunch of officers have been transferred during COVID times. And we send the summons to the original address where they were posted. They are not served. That is why we have given a.
Now
standing
you
instruction.
say that you have some officers, Pairavi officers, are you aware?
Pairavi officer, yes.
Yes.
We are directly in contact with them.
But what are they doing? Why this, we are releasing accused on bail because of the delay in trial?
what we do right now is that we summon all the summonses through the DIG administration with WhatsApp copies to the peer review officer also. Those are directly sent to the WhatsApp number of the concerned officers, the seizing officers.
You
in the
say
case.
that if they do not appear, you take departmental action. We want to know how many persons have not appeared and how many actions you have taken.
No, no, in some cases, what has happened that the officer who has seized the contraband in a particular case, he has to depose on that particular date in a different case where he is posted. In
So
some-
how will you coordinate this? Suppose one person is witness to 10 cases.
Yes.
You must have the information. Why this peer review officer says, no, he cannot come because he has already date is fixed. That is why, that is what that has been reflected. We'll reflect your name and call you on the next date in the order.
In one of tomorrow a case is fixed, 2022 matter, tomorrow we will be closing the evidence. So there is a proactive effort on part of the prosecution.
No, we'll see. We want to see this because your assertion of proactive part is not being reflected in those cases which we
I'm
are
making my
dealing.
submission only with respect to the court to which I am assigned.
No, just it's not against you. We are, because your state has given a very detailed report that these are the officers, these are the we are doing, but we are not getting the result while dealing with the cases. That
Yes,
is
the facts will vary from case to case because
no facts. We are not on facts.
No, I mean the reasons for they are not turning up. Those
But
will vary from case to
there cannot be any reasons of an officer not appearing for 2 years.
Definitely. For 2 years, definitely.
Then 1 day, 2 day, 1 day is missing is a different issue. That can be. Anyway, yes, let us come to this case. Yes, Mr. Datta.
Yeah, my lordship.
Yes.
We are here before this Honorable Court, Your Lordship, for quashing of FIR and charge sheet.
Where is the FIR?
FIR page 25. Lordship. The 498A case, Lordship will find there is no ingredients as reflected on prima facie on the reading of this FIR. Page 25. May I read or?
Yes.
To officer in such and such, 4th January 2021. I have the honor to report you that I was married with Sri Abhishek Shureka, son of Sri Jagdish Prasad Shureka, such and such, on 3/2/2012. Since soon after my marriage, I have been always tortured mentally by my husband and in-laws, including my father-in-law, Sri Jagdish Prasad Shureka, mother-in-law, such and such, Shureka, and elder mother-in-law, Srimati Devika Devi Shureka, in various ways. My sister-in-laws always similarly asked me to divorce their brother. They all in concert have been asking me and pressurizing me to get the marriage terminated. My husband has been repeatedly telling me that I was not of his choice and he would not keep me as his wife. All the other family members have also joined him and have been causing me various tortures in different ways and have made my life miserable. They have created such an atmosphere in the house that I would get suffocated mentally and agree to divorce my husband. Due to their continuous torture, I have suffered with various diseases like depression, high pressure, thyroid, insomnia, etc. They did not allow me to go freely to my friends, nor did they give me money for my basic needs. They never invited me to share food with them and always criticized whatsoever I cooked. In short, they put all sort of pressure on me so that I would agree to their demands or even commit suicide. They did never tolerate my stay in their house and always intended to send me back to my parents. On some earlier occasion also, I had to stay with my parents at Tinshukia, during which period they did never call me back. In the social circle, however, they always took me together to make a show of good relations. On my information, my
Where is
father.
the case diary? Case diary?
Your charge sheet has been submitted.
Huh?
Has been submitted.
Search sheet submitted, but we must see the
Statement.
161 statement.
Yes, that. Only Lordship kindly have a look whether there is the ingredients of section 498 is there or not. Because dowry demand is not reflected in the materials on record. No dowry. So far the torture is concerned, that is also not covers under the explanation of section 498.
To commit suicide.
To die.
To die.
No dates, nothing. The omnibus statement having general and omnibus statement.
What is the statement? What is, sir? Just go through it. Statement of the victim. Legma. Just go through it.
May I proceed further?
Yes, yes.
Other points. Lordship, when you have a look at chart sheet,
Hmm.
page 58. The Lordship will find the accused number 1. He is 75 years old. Father-in-law,
Hmm. Yes.
75 years. Date of birth is 1948. Supreme Court of Lordship is aware. The all in-laws dragged in court. Now Lordship the second, his mother-in-law, 68 years. 1955. Date of birth. Third is husband. May I proceed?
Yes, yes.
Yeah. Third is Lordship the mother-in-law, 68 years.
Hmm.
Now the husband. And fourth is this another auntie, she is 72 years. 51.
Just a minute. Yes.
Now, Lordship, and last is we are not connected with this. Fifth is Rupesh Go. Against him, he's a maid. Against him, 67 IT Act that has been charged. That has been charged.
Why?
He sent some vulgar videos, etc. That is the allegation in that. This maid. Against him, only 67. Not now, Lordship kindly comes to page 68, 64. (64J). A prima facie case under section 498A 34 is well established against accused person Jagdish, his father-in-law, Manju.
Yes, 64.
Page 64J.
Hmm.
A prima facie case such and such well established against such and such, such and such, such and such. Dabika, prima facie case under section 67 IT Act will establish against Rupesh Go.
What 67 ITX says?
67 says the
Yes, Parasar, have you got it? No 161. Just a minute, Datta.
Lord.
What is the statement of the accused Rupesh?
In the affair, there was an allegation against Rupesh is that he sent some
Vulgar-
pornographic videos through electronics mode.
It's 164 statement also against Rupesh last paragraph.
But against Rupesh, she says that this is not the, not the. Yes, Sahala.
My lord.
But may I?
Let us hear first.
Yes, yes.
Well, there is a specific allegation, my lord.
Where is the specific?
Torture.
What torture?
My lord.
There is a prima facie case of allegation, cruelty.
Yes.
But all cruelties will not come under 490 day. Cruelty can be a ground of divorce.
No, my lord.
At least you address us. Cruelty may be there that.
The demand of dowry is not necessary, my lord.
No, demand of dowry is not necessary.
Yeah,
That is what I am not
yes.
saying.
My lord, now, first your lawsuit may see 498A.
That we have read.
Whoever
Any
being-
willful conduct which is of such a nature.
Yes.
As is likely to drive the woman commit suicide or
to
cause grave injury or danger to life, limb, so and so, so and so, so
and
and so.
health, whether physical or mental. My lord, this is there. My lord, he has suffered, my lord, diseases. My lord, depression and other, my lord, affair, it is there, my lord. If your lord will see, my lord, that affair is very clear, my lord. Depression, high pressure, thyroid, insomnia, etc., my lord.
Thyroid, we have all.
My lord, no.
Thyroid, I am taking myself thyroid tablet in the body.
Okay,
No, that is
okay,
another aspect of it.
okay. What is the stage as on that?
My lord, they
No,
should
no,
have filed, my lord, 227 petition, my lord, before charge, my lord. Charge has not been framed, my lord.
Why should the 75 years
Just
old man to appear?
just wait.
My lord.
Prima facie, this court is of the view that subject to what you argue.
My lord.
But time will not permit today to conclude this matter.
My lord.
So we are staying the further proceeding and hearing this matter next week.
My lord, stay may not be granted because stay has not been granted till now, my lord. The matter has been admitted and at the time of admission also no stay has been granted.
What will the meaning of keeping it here?
My lord.
Either we dismiss it or allow it.
My lord.
And if we allow it,
My lord.
suppose, then already nothing has progressed in the lower court. Problem is this: there is no stay, but nothing has been done for since last 1 year.
Nothing has been done. Every day. There's a great.
So let there be clarity. We want clarity. We may dismiss it also. Prima facie, there is cruelty. Cruelty, but whether that cruelty is a cruelty to a magnitude from the statement of the victim. That's why I have gone through the statement of the victim and other witnesses. Got. That's why go through it and flag mark it. Those statements hard. Mr. Dr. Learned Senior Counsel, assisted by Mr. S. Deka, also Mr. G. and Sayola, Learned. No divorce, no permanent alimony till now.
There's contesting.
Who filed?
We filed. That
Okay.
is. They appeared.
And no, this is not. This is and Mr. G. and Sayola, counsel for the petition. The present application is filed under section 482, read with section 401 of the Criminal Procedure Code, praying for quashing the prosecution and charge sheet number 297 dated 36/2023 under section 498A IPC, read with section 67 of the IT Act 2000. In connection with Tinsukia PS case number 20 of 2021 under section 498A, under section 498A IPC, read with section 67 of the IT Act. Full stop. The petitioners herein are husband, mother-in-law, father-in-law. Yes, Mr. Doctor?
Yes, mother-in-law, father-in-law, mother-in-law, and auntie,
And
as well as the husband.
husband, mother-in-law, father-in-law, and aunt of the husband. Full stop. The basic grievance as discernible from the affair is alleged cruelty that meted out to the informant respondent number
Respondent number two.
On domestic scores. Accordingly, the offences as recorded here in below were registered. Full stop. Investigations was initiated, and after conclusion of the investigation, search sheet has also been filed. This court called the scan copies of the record and the case diary. Full stop. This court has also perused the statement of the victim and other witnesses recorded by the investigating officer under section 161, as well as statement of the victim recorded under section 164 CRPC. Full stop. Though aforesaid statement supports the allegation made in the affair, however, this court is of the tentative opinion that the nature of allegation made, though may be said to be cruelty, however, that may not come under the parameter, within the parameter under section 498A. Full stop. That being the position, this matter needs further consideration. Full stop. Mr. Sahela submits that there is some urgency, and on the other hand, Mr. Dr. Learned Senior Counsel also submits that there is no interim order passed. Therefore, the accused petitioners are to appear on every date fixed in the case, though the case has not progressed, inasmuch as the petitioner number, who are the mother-in-law and father-in-law?
Mother-in-law is
Petitioner
54.
number one, petitioner number?
Mother-in-law is one.
Uh,
The mother-in-law is one.
petitioner number
No,
one.
petitioner number is, sorry, your lordship, his husband.
No,
Three, four.
and petitioner number 2, 3
Four.
are the very old,
Yes.
are a very aged person. Full stop. As this court is of the view that matters needs further consideration and already has consideration, in the interest of justice, it is provided that till the next date, till the next date, further proceeding of the PRC case number so and so shall remain suspended. List this matter on. Why this matter? Yes. When, Mr. Datta?
Next week, anytime.
Next week or day after? Let us next week or day after? 19th? 19th.
20, no? 19 nothing about me? Could it be possible on 24th?
24th? Sayola? 24th. 24th of June.
Grateful.
49.
Which one is this? This is Bhattacharya case. Bhattacharya case. Where is Mr. Bhattacharya? Okay. Don't say non-appear because he was here. List this matter. As agreed to by the learned counsel for the parties, list this matter on even 26. Yes.
41 and 42.
Matter will have to be heard. Ready otherwise.
He says that matter may be remanded back in terms of Jacob Matthew.
I would like to point out one thing, my lord.
Yes.
Jacob Matthew paragraph 52 says that it is the burden of the complainant to produce the report. Nothing is there. So can he now be allowed to fill up the lacuna?
So if you see, we have for the time being, we have adjourned this with a idea that there may be a consensus. If you want to hear, then we'll have to proceed.
Lordship, in a private complaint.
No. You made a proposition that I have no problem, is a cognizance order is set aside, then it goes back.
But he has not
Now
agreed
he
to-
says, no, it is not possible. He will argue on merit.
On merit.
So if he argues on merit at 3:30, completing, dictating, will not don't want to keep it as CAB. So propose a date after vacation or what? Give a date.
Within the month of June, your lordship.
Give us that. For us, no problem. Because of this, today there is a division bench. That's why. Otherwise, these matters would not have taken up to 3:30.
We'll take a mutually agreed date and give it to the bench.
Okay, give a mutually agreed date and give, as agreed to by the learned council for the parties, list this matter. Yes, next case. Interim order, pass earlier shall continue till the next. Yes, Mr. Nath. Just remind us what was what.
My lord, the issue involved in this case, the petitioner working in the office of the treasury officer, my lord, in Jorhat. And my lord, his appointing authority, her appointing authority was deputy commission. Now, an application was filed, shown to have been filed by her before the treasury officer for BRS, my lord. For BRS.
Mr. Nath, we'll start it, but if we cannot dictate in the open court, we'll not keep it as a CAV.
Lordship wants to dictate in the open court to CAV, lordship will keep it CAV.
CAV will create a problem because I am not taking the criminal bench, this bench. It's a part-hard matter.
As your lordship pleases, my lord, I'm ready. Whatever lordship pleases. I leave to your lordship, my lord, no
No,
problem.
don't leave it to us. We have heard you, but the situation is such that if you ask me, I was thinking of releasing this matter from part-hard.
Lordship,
You
may
are
not
also suffering.
No, lordship may not release, my lord, keep it.
You are
We
also
need to stop that.
suffering. I am taking a criminal bench. It is an injustice to you also.
Doesn't matter, my lord, it's
From
not necessary.
coming to 498, 36, 37 of the NDPS Act, it has a sudden upturn from resignation, voluntary retirement, whatnot. But since you are waiting, that's why we have started it.
But if your lordships feel that, my lord, even if your lordships feel that, lordship not to, if possible to your something, your lordship, anything, my lord. And there's no problem with my 5 cents.
No,
Even-
it's not problem for you, but it hurts
No,
our
no,
conscience.
my lord, lordship is so open to all of us, my lord. Absolutely, there is no problem, my lord. I very honestly say, my lord. If your lordships feel that, my lord, after taking all these matters today, lordship want to take it another time, my lord, I have got no objection, or I can argue, my lord. I just look to lordships, my lord. It's part of the system, my lord. Today,
Yes, Nayak, what you say?
we will take another date, lordship, after vacation.
No, we'll give a chance. We'll take a chance. I want to finish it off. It's creating
Yes, I understand, my lord.
it's a
Let us
bur-
be, lordship is
it's
so-
a burden because we have kept it part-hard. We are not aware that it will be a criminal bench. Now you are also
It's not
insisting.
his fault, my lord. It's also not his fault because the roster it came like that. The lordship was never intention was never, my lord, to not to take up like that. We understand that. It is because the roster system.
But this will it will require some interpretation. It will have
Yes, yes.
it will have a far-reaching consequences either way.
Yes, yes, yes.
Say who will be the authority, what should be the process, the
Exactly.
period, everything
Yes,
will be
yes.
there.
That's why I'll place those, my lord. It's not that in 5 minutes I'll finish, my lord. I just want to place in.
I know that. That's why you will take some time. Half an
Yes.
hour it will require.
My lord. Then again, we'll take half an hour. Then it will be 4:30 again like this, my lord. Lordship, let us take a chance for next week once.
Dhar is also rushing.
Yes. one more chance.
But
Mr.
it's good that sometimes now I see the faces of Mr. Dhar, Mr. Nayak. We are only Mr. Goswami only.
My lord, it is because the roaster. Because the roaster. And they also, since morning, my lord, my other friend, my lord, he was doing 2-3 pardon matters.
Huh?
2-3 pardon
From
matters. in
morning, my lord, today all part had minutes, my lord, from morning.
Yeah, Mr. Nayak also, since morning, my lord, always they are very sincere. That I love.
Due to
There's no
paucity
doubt.
of this time, this matter could not be taken up. Let's make a list contest.
In this criminal bench, well, I don't know how long it will continue, my lord, because civil bench.
For me, it's an experience.
That's true, that's true, that's true. Because in the long run, my lord.
No long run, short run, whatever comes, that is the
Now my lord is in the other bank of the river, my
It
lord.
becomes
other bank of the river. He is correct.
it becomes an experience, my lord, from every.
But I cannot come to the other side.
Side is different, my lord. This is bank, my lord.
No, now I cannot swim to the other bank also.
No.
Friday.
The one-way traffic, my lord.
Mm. We are taking it on 26th.
26.
Yes.
Now, Wednesday, weekdays, my lord. Then there will be huge number of cases.
Wednesday is a better day for this court.
Okay, my lord, done. I understand.
Because
Yes, because
because all these bail hearing motion admission
over by 1 o'clock almost.
by 1 o'clock.
Yes,
Second half
my lord, keep it up.
26 due to possibility taken away as however as agreed to by land council for the parties leave this matter on 26th.
From our side, my lord, 3 of us, absolutely no problem, my lord.
So third 26th.
My lord.
Any other matter?